होय सर, होय होय
दिसते ना?
दिसते.
येस. ओके.
Yes, sir. PPT दिसते.
Okay. Okay. In the last session, we discussed about the Indian Contract Act 1872 of first unit, that is Law of Contract and Sale of Goods Act, A part. In this session, we will discuss about the Sales of Goods Act, which is a 1930, which is a B part of this unit. So, what is Sales of Goods Act? In the first, contract of goods, sales of goods is a special contract under the section 4 subsection 1 of Sales of Goods Act 1930, which defines sales of goods. In this contract, the seller transfers or agrees to transfer the property in the goods to the buyers for a price. So the person who sells the goods is a seller, and a person to whom he sells the goods is a buyer. In case Sales of Goods Act, it is a contract between the two parties where the one is a seller and another one is a buyer. आपण म्हणतो बघा काय आहे की एखादी वस्तू खरेदी करत असताना काय आहे, दोन पार्टींची गरज असते. त्यामध्ये पहिला असतो तो विक्रेता असतो आणि दुसरा असतो तो खरेदी दाता म्हणतो आपण, किंवा त्याला आपण काय म्हणतो, कस्टमर किंवा ग्राहक असं म्हटलं जातं. तर सेल्स ऑफ गुड्स ॲक्टमध्ये सुद्धा काय आहे, या दोन महत्त्वाच्या घटकांची गरज असलेली आपल्याला सांगता येऊ शकतील. तर त्यानंतर आपल्याला यामध्ये सर्वात महत्त्वाचे की पॉईंट्स पाहायचे आहेत. दॅट इज व्हॉट, काय इसेन्शियल ऑफ कॉन्ट्रॅक्ट ऑफ गुड्स, सेल्स ऑफ गुड्स, देन सेल अँड ॲग्रीमेंट टू सेल, then some of the subject matter of contract of sale, then transfer of property or ownership from one party to another party, then performance of the contract of sale where the actual goods are sale or not, then the conditions and warranties implied by the seller or the receiver, which is a customer, then the conditions and warranties, difference between condition and warranty, then doctrine of caveat imperator, then performance of contract of sales, which is unpaid or paid, then sale and his rights, then sale by auction. These are the some of main elements we have to discuss in this lecture. First of all, we will discuss about the essential of contract of sales of goods. In the first, two parties is there. For this contract of sale, there must be a two parties competent to a contract. One is buyer and another one is a seller. Buyer means what? A person who buys or agrees to buy goods, and seller means a person who sells or agrees to sell his goods. So in case of two parties, there are two persons come together and transfer the goods between each other. Then second one is a goods. The property which is to be transferred from the seller to the buyer must be in some goods. The goods which is from the subject matter of the contract of sales must be movable. There are two types of goods, which is a movable and unmovable. So the transfer of movable property is not convert uh, covered under this enactment of the Sales of Goods Act. So this kind of goods is also one of the essential element uh, comes under the contract of sales of goods. Then third one is a price. A consideration for the contract of sale is called as a price that must be in the form of money. So the goods, those are exchanged from another goods is called as a barter. So price is one of the most important element or essential content which is considered under the contract of goods, sales of goods. So this is also important. Then fourth one is a transfer of general property. There must be a transfer of general property from the seller to the buyer. For example, if A owns certain goods, he has general property in the goods. If A pledge such property to B, then B has special property in the goods. So This kind of a example also we can understand how the transfer the property to one person to another person. So this is also one of the most important essential element comes under the contract of sales of goods. So the property should be transferred one party to another party. Then fifth one is a essential element of valid contract. All the essential of valid contract are also required for the purpose of contract of sales of goods. So we discussed in the first section, that is A part contract act, some of the most important elements or essentials are required whenever you are going to make the contract. So these kind of contract also or elements also necessary in the respect of sales of goods act under the to making the contract. So this is also important element which is required in the contract of sales of goods act. These are the five most important elements given in the sales of goods of Act 1930. So from the fourth elements are there. That is one is two parties, second one is goods, third one is a price, and fourth one is a transfer of general property. And the all the elements which is valid the contract of sales of goods comes from the Contract Act 1872. So that is also one of the important factor which is used while making the contract between sales of goods act of one person to another person. Then we have to understand what is sale and agreement to sale. So first of all, we want to discuss what is sale and agreement to sale, where in the contract of sale, the property in the goods is transferred from the seller to the buyer. The contract is called as sale. But when the transfer of the property in the goods is to take place at a future time or subject to some conditions thereafter to be fulfilled, the contract is called as a contract or agreement to sell under the section 4 subsection 3 of 1930. So an agreement to sell becomes a sale when the time is placed or the conditions subject to which the property in the goods is to be transferred are fulfilled. In the case of transfer, in the case of sales, the actual goods are transferred to the seller to buyer, and in case of agreement to sale, the goods are transferred in the future. So this is the simple difference given in this uh, sale and agreement to sale. Now discuss about the sale and agreement to sale. What is the actual difference between them? The first one is a transfer of property. In case of sale, property in the goods transfers from seller to the buyer immediately. Here we discussed that the immediate goods transferred to buyer from the seller. It is uh, happened in the case of sale. But in case of agreement to sale, the transfer of property in the goods is to be take place at the future time or subject to certain conditions to be fulfilled. Sales is an execute contract and agreement to sale is an executory contract. म्हणजेच काय ट्रान्सफर ऑफ प्रॉपर्टीमध्ये काय केलं जातं बघा की जी गुड्स आहेत सेल्समध्ये काय केलं जातं इमिडिएटली लगेच काय केलं जाते त्या घेणाऱ्या व्यक्तीच्याकडे किंवा जो कस्टमर असेल किंवा जो ग्राहक असेल त्याच्याकडे दिली जाते आणि ॲग्रीमेंट टू सेलमध्ये काय आहे काही कंडिशन्स किंवा काही त्याच्यामध्ये अटी किंवा शर्ती लागू केल्या जातात आणि ती पुढच्या भविष्यामध्ये काय केली जाते ती दिली जात असते. तर अशा पद्धतीचे ट्रान्सफर ऑफ प्रॉपर्टी आहे. देन टाइप्स ऑफ गुड्स. इन सेल गुड्स कॅन बी एक्झिस्टेड or specific, and an agreement to sell is mostly about future or contingent goods. This kind of a difference is a from types of goods. Then risk of loss in case of a sale, if the goods are destroyed, the loss fall on the buyer even though the goods are in the possession of the seller. And in the agreement to sale, if the goods are destroyed, the loss falls on the seller even though the goods are in possession of the buyer. सो रिस्क जी आहे ती रिस्क काय आहे की वेगवेगळ्या पद्धतीने त्या त्या ठिकाणी त्या त्या व्यक्तीकडे देण्यात आलेली आपल्याला या ठिकाणी सांगता येऊ शकेल. देन consequences of breach in case of sale, if the buyer fails to pay the price of the goods, or if there is a breach of contract by the buyer, the seller can compensate the price even though the goods are still in his possession. म्हणजेच काय इन केस ऑफ सेल काय आहे की गुड्स जे आहेत त्या सेलर जवळ जर असतील आणि काही जर त्याच्यामध्ये काय झालं असेल की काही जर सेलरकडून किंवा बायरकडून काय जर प्रॉब्लेम झाला असेल तर त्या ठिकाणी काय आहे ते कॉम्पेन्सेट करण्याची जबाबदारी काय आहे त्या बायरची या ठिकाणी असू शकते. इन केस ऑफ ॲग्रीमेंट टू सेल, इफ द गुड्स आर डिस्ट्रॉयड, द लॉस फेल्स ऑन द सेलर इवन दो द गुड्स आर इन द पोझिशन ऑफ द बायर. सो कॉन्सिक्वेन्सेस जे आहेत ते कॉन्सिक्वेन्सेस काय आहेत त्या पार्टीवरती या ठिकाणी काय केलेलं आहे या ॲक्टमध्ये लागू करण्यात आलेले आपल्याला सांगता येऊ शकेल. देन फिफ्थ वन इज अ राईट टू रिसेल. इन केस ऑफ अ सेल, द सेलर कॅनॉट रिसेल द गुड्स. इन केस ऑफ agreement to sale, in case of resale, the buyer who takes the goods for consideration and without notice of prior agreement gets good title. In such a case, the original buyer can only compensate the seller for the damages. सो राईट टू सेल रिसेल आहे तो देखील या ठिकाणी काय आहे महत्त्वाचा सांगण्यात आलेला आहे. देन जनरल अँड पर्टिक्युलर प्रॉपर्टी. A sale is a contract or conveyance which creates and joins in rem, which gives the right to the buyer to enjoy the goods against the world at large, including the seller. An agreement to sell is a contract which creates just personam, which gives a right to the buyer against the seller to compensate the damages. So the seventh one is a insolvencies of buyers. In case of sale, if the buyer becomes insolvent before he pays for the goods to the seller, in the absence of the lien over the goods must be returned them to the official receiver or agencies. Then in case of agreement to sale, if the buyer becomes insolvent and hasn't yet paid the price, the seller is not bound to transfer the goods until he is paid for the uh, seller. So, seventh, then eighth, insolvency of seller. In case of sale, if the seller becomes insolvent, the buyer being the owner is entitled to recover the goods from the official receiver or assignee. And in case of agreement to sale, if the seller becomes insolvent and the buyer who has paid the price can only claim a ratable dividend and not the goods because property in them has not yet passed to him. So this kind of main differences we can discuss here between the sales and agreement to sales. So we go forward. Subject matter of contract of sales. According to section 2 subsection 7 of Sales of Goods Act 1930, goods means every kind of movable property other than actionable claim and money and includes stock shares, growing crops, grass, and things attached to or forming part of the land which are agreed to be served by for the sale or under the contract of sale. That is trademark, copyrights, patents rights, goodwill, electricity, water, gas are all the goods. These all categories of goods are subject to matter of contract of sales. So this is a subject to matter of contract of sales. Then classification of goods. So some of the classification is given under the act, that is according to section 27 of Sales of Goods Act. Goods means every kind of a movable property other than the actionable claim or money, which includes stock, shares, growing crops. These are the things attached to or forming part of the land which are agreed to be served by the sale under the contract of sale. So first one is existing goods. So what is existing goods? The goods which are owned or possessed by the seller at the time of sale are called as existing goods. The existing goods can be further classified. Uh, First one is a specific goods. Goods which are identified and agreed upon to at the time of the contract of sales is a specific goods. Then second one is ascertained goods. The goods which are become a certain subsequent to the formation of the contract or contract of sales are called as a certain goods. Then third one is unascertained or generic goods. The goods which are not identified and agreed upon at the time of contract of sale, these goods are called as uncertain or generic goods. So second one is future goods. According to section 2 subsection 6 of Sales of Goods Act 1930, the future goods means the goods which are a seller does not possess at the time of the contract, but which will be manufactured or produced or acquired by him after the making of the contract of sales is called as a future goods. Then third one is a contingent goods. According to section 6 subsection 2 of the Sales of Goods Act 1930 deals with contingent goods, which means the goods, those are future goods or acquisition of goods which by the seller depends upon the contingency which may or may not be happened. Then transfer of property. So here we will discuss the transfer of property. The main object of the contract of sales is transfer of the property in goods from the seller to the buyer. The concept of property in goods means the ownership of a goods, and possession of a goods means control or custody of the goods. The example is given: A is in possession of a car, though he is not the owner of it. B is not in a possession of the car, although he is the owner of it. So this kind of example is also given in this. So the some of the reasons which is necessary to know the movement of the time at which the property of goods transfers from the sellers to the buyers. Some of the reasons is given, that is first one is a risk follows ownership. Under the section 26 of Sales of Goods Act provides that unless otherwise the goods remains at the seller's risk until the property there is there is in transfer to the buyer, but when the property therein is transferred to the buyer, the goods are at buyer's risk, whether the delivery has been made or not. But if delivery has been delayed through the fault of the either the buyer or the seller, the goods are at the risk of the party at fault. Thus, the risk follows some of the uh, property. So, the second one is action against the third party. When the goods are destroyed by the action of a third party, the owner of the goods can take action against them. Then insolvency of the seller or the buyer. In case of insolvency of either the seller or the buyer, the official receiver or assignee can take over the goods or not. It depends on whether the property in the goods has passed from the seller to the buyer or not. Then suit for price. The seller can be compensated or sue for the price only if the goods have become the property of the buyer. So this kind of reasons also given in the discussion. So the rules for the for when the property in goods passes to the buyer are as follows. First one is goods must be ascertained under section 18 of the Goods Sales of Goods Act provides that where there is a contract of sale of uncertain goods, no property in the goods is transferred to the buyer unless and until the goods are ascertained. And second one is intention of the parties. According to section 9 subsection 1 of the Sales of Goods Act 1930 of the contract for the sale of specific or ascertained goods, the property in them passes to the buyer at the time when the parties intended to possess it. So this kind of also uh, given some reasons. Then performance of contract. The contract of sale has a reciprocal promises towards each other of the parties. The sellers promises to the delivery the goods to the buyer, and the buyer promises to accept and pay the money for them. According to section 31 of the Sales of Goods Act, the performance of the contract of sales means as a regard the seller the delivery of the goods to the buyer, and as regards the buyer the acceptance of the delivery of the goods and payment for them in accordance with the terms of the contract of sales. So the performance is also one of the important under the Sales of Goods Act, where the performance has been done by the both of the parties. So the next, delivery of goods. According to section 2, subsection 2 of the Sales of Goods Act, delivery of goods means voluntarily transfer the possessions of a goods from one person to another person. That is what sale from seller to buyer. So delivery of a goods can be uh, done with the delivery of goods done with the actual delivery, symbolic delivery, constructive delivery, and the rules as a delivery of a goods, that is mode of delivery, then delivery and payment, buyer to apply for delivery, place of delivery, time of delivery, then goods in possession of third party, cost of delivery, and last one is the installment deliveries. So this is the types of deliveries where seller has been done their duties or responsibilities against the buyer. So next one is rights and duties of buyer. So first of all we will discuss here what are the rights of the buyer. So first one is a right to have a delivery as per the contract. The buyer of the contract is have first right to have delivery of the goods as per the contract. So whatever the contract made between the two parties, that is seller and buyer, and whatever the elements or whatever the essential requirements are made in the contract that has been fulfilled by the both the parties, that is the right taken by the buyer from the this act. So the right to have delivery as per the contract is one of the major right have taken or given by the Sales of Goods Act 1930. Then second one is the right to reject the goods. If the seller delivers the goods to the buyer larger or smaller quantity than he ordered them, the buyer may reject the whole or accept the whole or accept the goods of quantity he ordered or rejected the rest. So rejection is the one of the right given under this act to the buyer, that they have taken the decision about the rejection and acceptance about the delivery of the goods. So this is one of the right given by the act. So uh, third one is a right to repudiate. The buyer of the goods has right to not accept delivery by the installment unless it is specially agreed between the party about the same. So this kind of also right given by the act. Then next one is a right to examine. The buyer has right to examine the goods before he accepted them, and the seller is bound to offer the buyer reasonable opportunity to examine the goods for the purpose of the conformity with the contract. So what is the right given under the Sales of Goods Act? That is right of examination of the goods whenever the delivery is receiving from the seller. So this is also given in the rights of the buyer. So last one is right against the seller for breach of contract. So under these, some of the right is given to the buyer. That is, one is a suit for damages in case where the seller neglects or refuses the delivery of the goods to the buyer. The buyer may sue or compensate to the seller for the damages for non-delivery. So this kind of suit for damages also right given under the Sales of Goods Act. Then second one is a suit for price. If the price if the buyer has not paid or paid the price and the goods are not delivered to him, in such a case buyer can file the suit or compensate for the price or recover the amount of the paid by him. So suit of price is also one of the right given to this buyer under this Sales of Goods Act. Then suit or compensate for the specific performance. If the goods are specific or a certain, the buyer may file a suit against the seller for specific performance of the contract to sell. So the performance is not fulfilled by the sellers, the buyer can suit against the uh, uh, completion of the performance in the specific period. So again, next is a suit for the breach of warranty. If there is a breach of warranty by the seller, the buyer may file a suit for the same. So in this case also the buyer have a right to suit a breach of a warranty. Then the repudiation of a contract before the due date. When the seller repudiates the contract before the date of delivery, the buyer may wait till the date of delivery, or he may treat as a contract as may file the suit against the damages for breach. Then suit of interest in a contract of sale. If the seller has committed breach of contract, then the seller is bound to refund the price to the buyer. In such a case, the buyer has a right to claim interest on this amount, that price refunded from the seller to him, and the date on which the payment was made. From that date, the buyer can take the interest, whatever the amount paid from them. So this kind of also right given under the Sales of Goods Act, which is rights against the seller for a breach of a contract. So these are the rights given under the Sales of Goods Act to the buyer side. Then duties of the buyer. So some of the duties also important given under the Sales of Goods Act, which is mandatory for the buyer. So first one is a duty to accept the goods and pay for them in exchange of the possession. So it is a duty of the buyer to accept the goods as per the contract and pay the according to the terms of the contract of sales. The buyer must be ready or willing to pay the price in exchange of for their possession of the goods. So this is one of the duty have been mandated by the act under the Sales of Goods Act to the buyer. Then second one is a duty to apply for delivery. It is the duty of the buyer to apply the delivery from the seller. So second, then third, duty to demand delivery at a reasonable hour. It is the duty of the buyer to demand delivery at a reasonable period of time from the seller whenever the purchases is done. Then duty to accept installment delivery and pay for it. In case of a contract of sale where it is agreed between the parties, the delivery on installment basis, it is the duty of the buyer to accept the installment delivery. Then fourth one is fifth one is a duty to intimate the seller where he rejects the goods. It is the duty of the buyer to intimate the seller in case of rejection of the goods if the damages or any kind of unhappened. Uh, then sixth one is a duty to take delivery. It is the duty of the buyer to take delivery of the goods within a reasonable time. So this is also one of the duty given under the section of Sales of Goods Act. Duty to pay price when the property in a goods are passed from the seller to the buyer. It is the duty of the buyer to pay the price according to the terms of the contract. Then duty to pay damages or non-acceptance wherein the buyer wrongfully neglects or refuses to accept the goods, he shall be liable for payment of damages for non-acceptance of the goods. So these kind of the duties given under the Sales of Goods Act to the buyer. Then condition and warranty, section 12, subsection 2 of the Sales of Goods Act deals with the condition. So the condition is a stipulation which is essential to the main purpose of a contract. It goes to the root of the contract. In the landmark case, Wallis versus Parrott 1910, gives the definition what is actual condition, that the obligation which goes so directly to the substance of the contract, or in other words is so essential to its very nature, that is non-performance may fairly be considered by the other party as substantial failure to a performance of the contract at all. If there is a breach of contract, then the warranty, section 12, subsection 3 of the Sales of Goods Act deals with the warranty. A warranty is a stipulation which is collateral to the main purpose of the contract. It is not that important as condition is. So the definition given by the Wells, that obligations which it must be performed is not so vital that a failure to perform it goes to the substance of the contract. In case of a breach of a warranty, the aggrieved party can only claim damages and has no right to treat the contract as repudiated. Then difference between condition and warranty. What is the actual difference between the condition and warranty? The condition is a stipulation which is essential to main purpose of the contract, whereas the a warranty is a stipulation which go lateral to the main purpose of the contract. In case of a breach of a condition, the aggrieved party can repudiate the contract of sales, and in case of a breach of warranty, the aggrieved party can claim damages only. Then, a breach of a condition may be treated as a breach of warranty, and in case of a breach of warranty cannot be treated as a breach of a conditions. So that is the difference between the condition and the warranty. So then we will discuss about the rights of an unpaid seller. So first right is a rights against the goods in